Welcome back from the break. You're still watching Our Parliament, and I'm your host, Iguma Gabriel. If you would like to send an SMS, a comment about what you've seen on the show, you can send that SMS to 0793 893 719. That number is showing at the bottom of the screen. You can also go to Twitter. Our Twitter handle is Our Parliament TV. If you're leaving a comment, you can use the hashtag Our Parliament. Facebook, we have a page, Our Parliament. Before we went for the break, Sydney Asubo, who is the Director for Legal Affairs from the IGG's office, was just explaining something to us. Sydney, please go ahead.
Yeah, I was explaining what a predicate offence is. Now, these are the offences from which the proceeds that the criminals seek to launder is derived. And there are two approaches that are recommended by FATF. One is what they call the list approach, where you list all the offences that will form the predicate offences for money laundering. There are 22 of them that are listed in the addendum to the recommendations. These range from drugs, drug dealings, murder, financial crimes, tax evasion. The list is quite comprehensive, and robberies. Now, the other approach is what we call the all-crime approach. Uganda took the all-crime approach. In other words, any crime from which you derive the proceeds is a predicate offense. And our studies have shown that in Uganda and Africa and many other countries across the world, the main predicate offense for money laundering is corruption. In some other countries, like Latin America and it's drug dealing. So, and in fact, when the initial target for dealing why these things came out was initially the drugs. That's why the Palermo Convention is very important. And the first recommendation for the FATF recommendations is you must, as a country, be a state party to the Palermo Convention, the Vienna Convention, because those deal with the drugs, and then the terrorism, the anti-terrorism, the global anti-terrorism frameworks. So those are the predicates. So ours is all crime. Now, secondly, of course, the fight against corruption is much wider than what the Act provides. The Act is one of the tools that will be used to fight corruption. Now, the other distinction with this Act is that, like Robert has rightly observed, you do not have to secure a conviction for the predicate offense before you charge or prosecute somebody successfully for the money laundering. For example, if somebody has embezzled funds, you do not have to first secure a conviction for the embezzlement before you can charge the person with the money laundering. So that's a distinct provision in the Act. Okay. The reason for that is that we know if you across the world, not only in these money laundering things, even for recovery of assets, if you hinge recovery if it's criminal based, it's a problem. Now, the problem we still have in Uganda is that we do not have civil-based forfeiture. Ours is criminal-based forfeiture. So that is the problem we have. But this one gives us a leeway that you do not have to first secure a conviction.
Okay, let's go to the audience. The audience has questions. I have a gentleman in the front wearing a red tie.
My name is Okiror Joseph. I am a lawyer by profession, and I appreciate the submissions of my learned brothers. But I have a few concerns about the law that I need to seek clarity. Number one, the law seeks to combat corruption.
Among other things, yes.
Among other things. So, I'm wondering, I've not had the opportunity of looking at the details of the law, which I think my brothers could have. If somebody has stolen money, for example, a public servant has stolen money from Uganda and banked it in Nairobi. Okay? He has stolen 2 billion. He has banked 1 billion in an account in a bank in Nairobi and part of the money in Uganda. So the question is, does this law harmonize with the regional laws that can be able to audit trail somebody's financial record, such that it can be sent back or that information can be got from Uganda for purpose of prosecuting that kind of person?
Okay, let's put that question to Robert here. We'll come back to you for another question. Yes, Robert.
With regard to the question of, I think there's actually two questions in what you ask. If you're asking whether the funds in Nairobi can be recovered after there's a conviction, the answer is yes. because the law talks about the recovery of any property. Now, I may have my issues on what the structure that the law took, which differs from the structure that Nairobi has taken, for instance. But in the end, the consolation in this act, in this particular scenario, would be that jurisdictional exclusivity. The act specifically provides that where a Ugandan or someone of Ugandan citizenship is involved in money laundering, Uganda has jurisdictional exclusivity. Now, once we discover where that money is, or once the state discovers, there's a mechanism within the act under which that property can be recovered, because it is all tainted property.
And if that money is actually gotten back, where does it go?
It then goes to the state coffers.
Oh, so
Well, yes.
it was stolen from the state coffers, and we bring it back to people who most likely are going to steal it again.
Now, no. Now,